I know say EFCC they look for Yahaya Bello. And now a lawyer don't come and come to tell us say, as far as he don't go represent a client is no longer supposed to be running, hidden. Let me use that word. So anytime, any day, they feel see clients for anywhere. They not get right to take arrest, and even if you go EFCS doorstep, they don't get right to take arrest. And my question is, clean conscience, what are you fearing? What are you scared of? Because according to what we know, clean conscience, they don't fear any kind of accusation because they have their parents are clean. Okay, that one are my own suggestion. Secondly, law not be the same for everybody. I wish this man was not a politician. Therefore, don't babble. Therefore, don't cash and be. As far as he's a politician, they never feel cash and be. Mona see the full updates. I beg.
He stated that court orders must be respected and obeyed by the EFCC.
Based on what transpired in court, there are two facts to be gleaned without delving to the strength or otherwise of the matter, because that part is sub judice. Now, the two facts to be gleaned is that there is an order for arrest that has now been contested before a judge, for which it has been adjourned for ruling. EFCC is not supposed, after today, to be chasing Yahaya Bello anywhere. Even if he's walking in front of their head office, they are not supposed to arrest him, because now it has been contested before a court, and court has adjourned for ruling. Two, there is an application by Yahaya Bello that order of arrest should be stepped down because it has been overtaken by event since I have now been served. And on the next adjourned date, it is only when I don't show up that the court can be requested to issue a bench warrant. But now, having served me, the law requires for me to study the charges ahead of my arraignment. And so arresting me will amount to breaching on my right to prepare and come and take my plea. So, and that request, that order of arrest should be invalidated, has not been granted or refused because it has been adjourned for ruling. Where these two facts exist, the way we know it, we teach students in law school, is that party must maintain status quo pending the hearing of the various applications and objections, so that court will decide. If on that day, the court says, your request to set aside this order of arrest has now been overtaken by event because you are already before me, then fine. If the court says on that day you are not before me, so that means this order to arrest will have to be extended. Even if you throw away, there will naturally be a request that a bench warrant be issued since you have not appeared for your arrest. If the court set it aside, then you proceed to trial.
Meanwhile, the Commission has filed a notice of withdrawal to discontinue an appeal against an order of a Kogi High Court restraining it from arresting the immediate past governor of Kogi State, Yahaya Bello. In the notice filed on April 22, the EFCC said the withdrawal is predicated on the fact that events have overtaken the appeal. Joining us now on the morning show is Muiz Banire, a senior advocate of Nigeria and former commissioner for environment, Lagos State. Good morning and welcome to the morning show.
Good morning, my pleasure.
Dr. Banner, good to have you on the morning show. Quickly, two things. One, the EFCC versus Alhaji Yahaya Bello. There are many issues that are out there in the public domain. Should the EFCC have disobeyed a court order when there is a restraining order? Or did the EFCC act lawfully, in your view, in laying siege on Yahaya Bello's home in Abuja? Number two is the latest development, Okutakpa SAN discontinuing an appeal that they had filed against the judgment of the Kogi High Court, Kogi State High Court. Now, what is the material effect of that in relation to the case before the court of Justice Emeka Nwite at the Federal High Court in Abuja? Those two things to start with.
Well, in the first instance, let me categorically say that to the best of my knowledge, EFCC have not disobeyed any court order at all. Most of the people that have been peddling that information certainly have not read the judgment. I've had the privilege of reading the judgment, and if you read it, I'm sure probably, most likely you have read it yourself as a lawyer, you will see that the import of the judgment is to say, refrain from harassing him, from defaming him, and so on and so forth. But the judge himself in that judgment put a caveat there to say that, however, where the Federal High Court issues any order, that order should be obeyed. And secondly, he also gave a directive that if they have any allegation against Yahaya Bello, then such to be formally brought before the Federal High Court, which EFCC has done. So in the light of that, you will discover that there is consistency in the two judgments. Prima facie, if you see it, you would think that there is a contradiction. But if you have read the judgment and what has transpired at the Federal High Court, there is no inconsistency and no court order has been disobeyed thus far. That's number one. With regard to the notice of discontinuance, of course, that is just consequential because the appeal before the Court of Appeal was in respect of the ex parte order, the interim order made by the Kogi State High Court. Eventually, the court had given the final judgment, thereby rendering otious the initial ex parte order. So it has become meaningless and spent. The appeal is spent. It's been overtaken by the subsequent judgment. So if there will be any appeal at all, it will be against the substantive judgment rendered by the Kogi State High Court, not the ex parte again. And that's what has happened. And it has no impact, no nexus with the proceeding before Justice Iwite at all.
Thank you very much, Dr. Banire, and great to have you so you can just clarify a few things, especially yesterday we had Daniel Bwala. I don't know if you've seen that interview, and we also had an opportunity to dissect the matter where the EFCC chairman had held a media parley and had almost as if explaining the side of the EFCC, breaking down the efforts of the EFCC to invite in former Governor Yahaya Bello and his resistance thus far. A number of people have seen that as being perhaps having an adverse impact on the case at hand because it's already, they're hoping to charge him to court and he's already being, as I would say, defending his own case before his own court. What do you make of that? Do you think that the EFCC perhaps ought to have stayed low in terms of providing information, not conducting a media trial in order to strengthen their case and not in any way adversely affect their case against former Governor Yahaya Bello?
Well, I'm sure that it's not the public that is going to determine the case ultimately. I'm sure from what I've seen, my own observation, the EFCC was drawn out by Yahaya Bello through the various statements credited to his own media team. And they felt that they need to respond to the public opinion on the issue. Because again, you will discover that what he has said, what they have said, that is the media team, is that there have been a disobedience of court order and so on. He was never invited and so on and so forth. But even in his own affidavit, if you have read the judgment of the court of Kogi in respect of the fundamental, you will discover he himself affirmed in the affidavit that actually he was invited, and he confirmed that he was invited, and all. Those were explanatory things that has nothing to do with the substance of the case before the Federal High Court. In fact, I observed that the chairman struggled as the lawyer throughout that media parley to avoid touching on the substance of the case before Justice Iwite. So to that extent, if it's something to do with the general effort and to respond to the public outcry, I'm not too sure that is harmful to the administration of justice, particularly in respect of the subject matter.
Okay. Dr. Banire, good to see you. I want you to react to what a lot of people are now saying against the EFCC, that the EFCC chief shouldn't have come out to grant that press conference, that he said many things that can be used against him, you know, against the EFCC in the court of law that could destroy the case. Things like when he said that he granted Yahaya Bello privileges and the likes, and he was talking about the detail of the 720,000 and all of that, because there's been a lot of blowback to the EFCC. I want you to clarify all of that.
Well, my very strong view of it is that the courts are insulated from all those social media or media parley information. Judge is not meant to live by those pronouncements from the media parley at all. So if you look at it critically, that is the evidence before the court that ultimately will determine the fate of the defendant. It's not what was said outside there. If, for example, I say to you now that you stole 500 million naira, and I'm unable to provide any evidence before the court. Even if I said to 1 million times in the public space, it amounts to nothing. So I do not see it in any way hurting the case of either parties before the court. Like I said initially, what had happened is more or less a situation where you had to respond to public information as to the issue of the aggression by the EFCC. So I'm not sure they have stepped out of their bound by so doing at all.
Okay, Adedipe SAN, who is counsel to Yahaya Bello, approached the court, I think this week, asking that the bench warrant order be vacated. And there's been an adjournment, I think, till May 10. Now, a substituted service has been given to the lawyer to pass on to Yahaya Bello, which means it's now been properly served in this particular matter. What should we expect next? Both from the EFCC
what we expect is that
and from the court.
What I expect.
Yeah, please go ahead.
From the court, my expectation is that arrangement proper will take place at the next adjourned date. And now he has been served with the charges, including the proof of evidence, which I expect that his lawyers by now will have been studying alongside himself, so they'll be able to prepare their case and come before the court to either apply for bail. It's a bailable offense, and if the court is so disposed, bail is granted, and at the end of the day, he probably will regain temporarily his freedom to the determination of the matter. But on the part of the EFCC, if they are ready to prove their case in some court, the matter will proceed that day if they have their witnesses on ground. In some other court, the court will adjourn for a specific date for trial to commence. So that is the expectation.
But Justice Wite still has to address the matter about the vacation of the bench warrant, which counsel requested for.
Well, my view of it is that if, for example, on the next adjourned day, Yahaya Bello turns up in court, then automatically the warrant of arrest becomes spent. So there will be no need, it becomes academic, there will be no need to even rule on that again. But if otherwise, that is where I partially disagree with Daniel that, look, a court order until set aside is alive, is extant, is living, and we must abide by it until set aside by a competent court. Otherwise, you still must abide by that order of court.
Let's go back to the claims made by the media office of Yahaya Bello, saying that he wasn't even invited in the first place by the EFCC, and they should make proof of the fact. And bearing in mind, during the media parley, it did seem like it was just a verbal, I don't know if a written invitation was made to Yahaya Bello. In the event that there was no written invitation, would they then have a case to say that there was no reason to have come to arrest him if the EFCC had not, in fact, invited him formally into their office for questioning?
Well, to the best of my knowledge, from what he himself said, that's why you need to go and read that judgment, or that particular judgment he obtained from the Kogi State High Court. He himself deposed to the affidavit to the effect that I was invited. He said that much there. So that is an admission of fact. So that is not in dispute. It's not a contest again that he was invited. He stated there, you may go and look at that particular affidavit that was deposed to in support of his claim for fundamental human rights. So that is not in dispute again.
Okay. So, I mean, there are many other